Glad to see everybody here today, being attentive. Ask questions throughout my presentation whenever you have one, because we all have legal questions. The notes are, if you follow along with the PowerPoints, the notes are going to be provided for you later date, probably within the next day or two, I believe. So first I want to just talk about myself, hospitality law, my background. I was basically going to be in your position at one point.
And you got smart.
No. I always had a passion for food and the food industry. I mean, going back to college, I remember I did my demonstration speech on how to make creme brulee. I love the food industry. However, it just seemed like law was a better suit for me at that point. So I practiced law, went to Villanova Law School, practiced law for a couple of years, at which point I said, why am I doing this? Why am I practicing law? I had this passion for food. I went back to culinary school. Went to Johnson & Wales in Charlotte, came back to Philadelphia to help open a restaurant. I spent the past 7 years working in the restaurant industry cooking, primarily Italian. Breads and pastas are my specialty. But along the way, I became more involved in hospitality law and teaching at Drexel University. So it's great to see everybody here is following their passion. It's amazing. I think more people, get to the point that say, this is what I want to do. I'm going to make it happen. And it's great that the Enterprise Center is here to help you make it happen. So when I went to law school, there wasn't a class in hospitality law. There wasn't like, oh, you sit down and take hospitality law. Hospitality law, culinary law, encompasses so many legal dimensions, so many things that we see day in, day out have a legal element to our work. It's been, estimated that 65 to 80% of all our decisions that we make in our business has a legal element to it. From dealing with purveyors, from dealing with customers, contract law. We're dealing with contracts every day. How often do we sign something with our business? A delivery gets, dropped at the door. We sign for it. That's a contract. Contract law, we're going to go over some basics, things to look for. Just touch base on what we know and where we're going with contract law. Property law, Enterprise Center is great, but we all want to establish our own kitchens. We all want to establish routes. So we're going to highlight some things to look for with our leases, steps that we, to go forward in establishing our own property, our own storefront. Employment decisions. Our employees, and how many people here have employees currently on payroll? One. But eventually we're going to get bigger, and we're going to have a lot of employees, and with employees, there are, representatives to the community, our business, which is great. But there's also bad employees out there that could defame your business. So we have to know about how we're going to go about hiring people, all the way to then about how we're going to legally fire and terminate employees to protect ourselves in the future. Duty of care, we're going to talk about negligence, our responsibilities to our customers. What can we be sued for? How do we prevent these lawsuits from going forward? And lastly, I'm going to touch, we're talking about serving food. Rose talked about it earlier about, food safety, sanitation, but we're also talking about allergies, and I'm going to briefly mention some things that are occurring throughout the U.S. and various states concerning allergen laws, and stuff that's eventually going to occur in Pennsylvania, and we're going to have to know for the future. Next slide. Contract basics. There's 4 main elements that we need to know with a contract. The first element is that the contract has to be legal. Well, what does that mean? That means that the items that we're dealing with in the contract have to be legal. So we're serving food. Generally, we're going to have, food is going to be legal. There's no laws behind it. But if we're going to eventually open a bar, a restaurant, serving underage people, that is illegal. So with a contract, it has to be legal in that, and also, there has to be, the people that we deal with have to have the capacity to contract. So if we're entering into the contracts, those individuals have to have the right mental capability and capacity. So we can't enter into contracts with minors, we can't enter into contracts with people who are mentally retarded, people who are, imbibing alcohol. Those contracts will be null and void just because of the state of mind that they are in upon entering the contract. The second part of a contract is the actual offer. Offer is generally a promise to perform, a proposal. What's important to note is that when we enter into these offers, let's say we're in a business and we're dealing with our purveyor, and we say we want flour at X amount of price, say 100. And they say, no, I can't give it to you for 100, I can only give it to you for 150. You come back and say, well, I'm not going to accept your proposal, I'm done. If the purveyor comes back and says, you know what, I'll take it, you can buy it from me for 100. That is a counteroffer. You are not held to his offer. No contract has been formed. So when we get into steps of negotiation, the actual offer has to be a mirror image of the initial offer that you give. Does that make sense? Questions? I'm going to be touching on a lot of things, so feel free to ask questions throughout. Our accepting a contract can be done in many ways. And one of the main things that I want to talk about is to make sure everything we have is in writing. We're going to talk a lot about how do we prevent lawsuits. Because that's what we're here for. None of us want to deal with an attorney. None of us want to pay those fees. None of us want to go to court. What steps are we going to take to prevent this? So,
you said about, say you offer, I'm going to sell it for 150,
yeah.
And the counter offer, okay, let's make it 125. Why it has to be, I didn't understand the part, it has to be the initial offering.
So,
if we both agreed on the 125,
then that's perfect. But if he or she goes back and says, you know what, I'm going to accept your original offer 100, you don't have to agree to it because he gave you a counter offer. In the counter offer, it totally wiped out that original offer that you had for 150. So it's a simple negotiation. Most people think that they're tied into our original offer, but we're not. Once the negotiation begins, the terms of the offer change. So that original offer of, say, 150 or 100 does not lock you in, because you could have, after this person offers a different amount, you could be like, I really don't like the way this is going. I don't like the bargaining tool that this guy is using. I don't want to deal with him. You don't have to at that point. You're not locked into that initial offer once the negotiation begins. Acceptance can be written, and that's what we're going to highlight tonight. We're going to highlight how we want it all written, we want it documented, we want things to be as clean as possible in case we go to court. And it's amazing now, we say written. We're talking fax, we're talking emails, we're talking text messages. Those are all ways that we can accept a contract in a written form. And how often do we just send out a text or an email without thinking? There's liability there. Acceptance can be through payment. We are dealing with customers. They give us money. We accept it. Contract is formed. Or a deposit, if we're talking about a bigger, restaurant, catering operation, put down a deposit for a large order. Lastly, it's consideration that the courts are looking. It's just a flow of promises between both parties. We're going to do this, and you're going to do that, and therefore consideration is flowing. With contract goes hand in hand with breach of contract. What do we do when our contracts are broken? Generally, if we're going to court, the court's going to offer 4 different options that we can to recover our expenses. First is specific performance. So if you're agreeing to say that you're going to perform this contract and you're going to provide these goods, the court may or may not force you to provide those goods. Courts generally do not want to do that because they don't want to force people to act in a certain way. More than likely, they're going to offer liquidated damages, which are penalties. They're going to reward you for the contract terms, but they're also going to penalize the party breaching the contract to say, you know what, you broke the contract for $100, we're also going to penalize you $50 just to penalize them, bring this person back to the place that they should have been. Economic loss concerning large-scale contracts, the courts can say, well, you lost business because this contract was broken. You weren't able to fill your restaurant, your corporation, So we're going to reward you for the potential loss that you lost in the future because this contract was not fulfilled. Lastly, there is alternative dispute resolution, and that is when you don't want to go to court. Because court is long, it costs money, so there's a process out there, ADR, in which you could either have arbitration, which is a neutral third party sitting there, hearing the facts of the case and rendering a final decision, or mediation, which is an agreed upon third party. Both parties will sit and say, we agree to this mediator, and this person is going to be there to help you compromise, make a decision, and not render a final judgment. Both parties have to agree to the end ruling in mediation. So arbitration, it's a final ruling. Mediation, both parties have to agree. A lot easier, cleaner, less drawn out than going through the whole legal process. Next slide. So what do we do? How do we form contracts? What steps do we need to take to make sure our contracts are as tight as possible and have no loopholes and we're not going to court? First, as I mentioned, get it in writing. Verbal contracts are a problem. There's going to be a lot of ambiguities. You go with a verbal contract and there's a problem. Well, they said this and he said that, and this. It's sloppy. We're going to have bigger issues in the future if we don't get it written down. And when we talk written down, you're getting the basic key terms. We don't need to draft out long formal documents through our attorneys. It's having a set, prices. So when we talk about what we want in a contract and get in writing, the dates, price, time frame, when and where things are going to get done. We want to hit all the key terms, because when we don't hit those key terms, people are going to interpret it in various different fashions, and that's when the problems occur. You want to read the contract thoroughly. So if you're dealing with a purveyor, you want to make sure that the terms are according to what you discussed, rather than just signing it. Because we have all entered into contracts where somebody hands us a piece of paper and they say, can you sign this? And you sign this. If we sit there and actually read the contract, read it thoroughly, we're going to make sure that there's no hidden terms, nothing that's going to cause problems in the future. You want to keep copies of all documents. How many people here actually have a file folder, a space, specifically in place with all their contracts, all their documents? Beautiful. We want to have everything neat, organized, separate files, so that if problems do occur in the future, we have it all organized and we're going to prevent any problems. So if we go to court, we can present documents and say, this is the issue that it had, here's all my documents. It's going to help you out in the future. You want to use good faith in negotiation, in that when we enter into a contract with bad faith and bad terms, it's going to get messy. There's going to be problems. So if both parties are entering the contract in good faith, we're not going to have as many issues. So when I talk about, briefly, we're negotiating. If you're negotiating with somebody that you don't really trust, don't get into a contract. Start clean, end that relationship, and start negotiating with somebody who has a good business record, has good business ethics. You want to prevent these lawsuits. You want to note and calendar all time deadlines. So if this is to be formed on this date, we have a calendar in our office saying, just noting it so we can follow through, because you don't want to put a contract away and then totally forget about it, because there's going to be specific dates and how we're going to have to perform things. You want to ensure performance of third parties. So depending on how elaborate your contract is, you may have a third party involved who has duties and obligations. And if you're responsible for that third party, you can be sued for their failure to provide their goods, services. So in who you're dealing with in your contract, you want to make sure that they're fulfilling their obligations so it doesn't ultimately fall back on you. You want to share information with those parties who need to know. So whether you have a manager or fellow employee, explain in detail all the contract information you have so that you're both on the same page. And lastly, before you get into any contract problems and you read it and you see there's an issue or you don't understand a term, resolve all ambiguities. Discuss these. And a lot of this stuff that I'm going to talk about seems, kind of common sense, but it has to be reiterated because it's so often that restaurants, food purveyors are getting sued because they forget about little things. And the little things add up and they're going to cause the ultimate problem. Next slide. And I'm going to touch on property contract law because it's all connected. It's all connected in hospitality law. But we're here. We're at the Enterprise Center. They have a lovely facility. It's amazing. But ultimately, we all want our own restaurant or our own space that we're going to work out of, and we want to establish roots. So property law is a huge issue. There's certain essential lease terms that we have to think about when we read a corporate lease, a lease on a property. First being the length of time. Could it be for 1 year? It could be 3 years. It could be for 5 years. All this stuff can be negotiated. It's all about deciding whether or not you want to be fully invested in that space for that amount of time. We talk about, go back to essential lease terms, we're talking length. You want to talk about rent amount, when rent's going to be due, paid, your subleasing rights. So you enter into a property and you sign a 5-year lease, and maybe it's not working out. And now you want to get out of it and you want to sublease it to somebody. It's important to note in that property document, your lease, whether the subleasing rights are yours, whether they need landlord approval. You know, if you just glance over it, you may not have any subleasing rights, and you may be tied into that spot. You also want to look at, termination rights. How are the contracts, the property lease going to be terminated? Do you have to pay on a certain date, and you can be evicted? What leeway is the owner, landlord going to give you? Chattel and fixture are two big important issues to think about when we enter into a property. The Enterprise Center has everything here. They have these assets, and it's great. But say we go look at a property, and we get in there, and we think, this is my dream kitchen. Everything's here. Well, will everything be there when you actually sign the lease, when you move in? So two things to think about are chattel, which is a movable object instrument. So sheet racks, pots, pans, they're all movable. Your Hobart mixture can be movable. When we talk about a fixture, we're talking something that's permanently attached to the property. When it's permanently attached to the property, it becomes part of the property. Versus a chattel can be moved without any damage or destruction to the actual property. And I've been through restaurants and restaurant openings where you go in and you think, oh, great, all this stuff is going to be in, and I negotiated it, and it's not in writing, and then you get in and your Hobart mixer is gone. The sheet trays that you thought were going to be there are gone. The pots and pans are gone. Those are fixtures. They are movable. They do not permanently attach to the property. So in getting the property, you have to negotiate what items are included. So there would have to be a separate bill of sale to that, because things disappear. Buying or leasing is another issue when we think about property law, and it can be as simple as money. Buying a property costs a lot of money. Leasing it costs less. But if we're coming down to the actual decision of whether we want to buy or lease, there's certain things we want to think about. First is the right to use. If we own the property, we own the building, we own the roots, we can do whatever we want with it. Versus if we're leasing the property, our rights can be limited due to the actual property lease document. So the landlord may or may not need approval to everything that you do. The ability to finance. If we own the property, we can use it as collateral to develop our business, buy equipment, grow our business in separate locations. Leasing the property, we have no ownership rights. We can't use it as collateral. It is just our storefront. Improvements. We're leasing a property, we can make improvements, but we have to realize that we're not going to get that money back for whatever improvements we made. The improvements stay with the property. They stay with the lease, and versus if you own it, you make improvements, you can, ultimately enjoy the benefit of those improvements. So if you have a property and you have a 1-year lease and you go and you clean it up, you make it nice, you put new windows, they're part of the property. The owner's going to get it at the end of the lease term. You may have a nice owner who will negotiate with you concerning, the improvements that you're making. But you could also have a landlord who just doesn't care and is not going to reward you and is not going to give you any money. And I've worked in a kitchen where there was an apartment upstairs, the landlord owned the building, well, something's leaking. And the landlord just didn't do their job. They let it leak to the point where the restaurant owner who had the lease just had to go out and pay for the repairs himself and the improvements. These are issues that we need to think about. Termination, if we have owned the property upon our death, the lease or the actual property will pass upon to our heirs. Versus if we lease a property and something unexpected happens, the lease ends. So you could have that right-hand man or woman working with you who's ready to take over your business, but you die, your name's on the lease, the business ends. That lease agreement ends, and this person, A, will have to go into negotiations with the landlord to say, hey, can I continue this lease? Some landlords are great. Some landlords aren't. But these are things that we need to think about. You default upon your lease, you're going to get evicted. Plain and simple. How quickly that process goes depends on how irritated your landlord is, how backed up the sheriff's department is in the actual eviction process. But it's important to know that you could be out of there pretty quick. Next slide. Employment law is huge when we talk about our businesses, and we're growing. We want employees. We want to grow our businesses. We want to make money. We're going to have to get employees eventually. Employees could be the greatest asset, or they could be the biggest detriment. What I like to teach, and when I teach my students, is a philosophy called STEM. It's all about preventing lawsuits. This lecture is all about preventing lawsuits, and when you get contacted, this is the steps you need to take, and then eventually contact a lawyer. But we all are here to do our due diligence and prevent lawsuits. So with STEM, it comes down to selecting employees, training employees, educating employees, and lastly, managing and motivating them in the right ways. So when I talk about selecting employees, how do we go about selecting employees? Do we have a friend of a friend who recommends somebody to come talk to you? Do we place an ad on Craigslist to have help? When we think about our qualifications that we're looking for, we need to have set and specific qualifications. And if you look at Craigslist, you see companies that can have a real defined set in terms. And then you can have places that are looking for employees that are one sentence, and they'll say they're looking for somebody who's passionate. Well, we're all passionate. Doesn't mean that we're all competent. Doesn't mean that we all know how to do our job. So having these details and what we're looking for, they have to be spelled out. So whether we're looking for somebody with a culinary degree, whether we're looking for somebody with serve-safe responsibilities, certain educational requirements, basic things that you see with like physical attributes, and that companies want you to be able to lift 50 pounds. Why 50 pounds? We have 50-pound bags of flowers. We have 50-pound bags of onions, carrots, etc. If you can't carry that weight, you could be a hindrance to the business. You could be a liability. So those are things that we, want to spell out in what we're looking for in our employees. And selecting our employees, we don't want to get in the habit of just hiring somebody at the last minute. We want to find somebody who is truly qualified, and it may hinder our business operation in the future that we have to go without an employee for 2 weeks, 3 weeks until we find the right one. But I like to equate it to the whole situation with a dam that's leaking. Certain people will put bubble gum there, and the dam's going to get worse and worse, and then it's ultimately going to collapse. Certain people are going to take the time to fix it and fix it right. By fixing it and fixing it right the first time and getting that right employee in, we're going to prevent future problems down the line, and we're going to touch on this with training. So when we screen our applicants and applications, we want to make sure that we ask legally valid questions. Questions that are non-discriminatory, that are getting in trouble, and it's amazing how often employers will ask the wrong questions, or they'll make the wrong comments. We have to be careful in what we ask, what we say, and how we actually review the application. looking over these applications, resumes, we have to be able to notify and see where the problems are going to be with our employees. So certain employees, you'll look and you'll see huge gaps in employment, or that they've had, 5, 6 jobs this year. Well, do we want to waste our time training this employee again who could leave us in a month, and then I have to go through this whole process again? Large gaps in employment, why aren't they working? What's going on? What's the issue? You don't want to get too deep about their medical, but they could all, just, why didn't you work during this period? And it could be simple excuses or simple reasons that, I was very sick and ill, I couldn't work. That's fine. But it could also be that, I was jumping around, or I didn't put this job on my application because I didn't want you to notify that employer because I don't have a good relationship. It's examining the resume, examining the application, and being able to see what problems are going to be there. Training and educating, we want to train our employee right the first time. How do we train our employee right the first time? Well, we have a qualified person there to train them. So this person, more than likely you want to have the same person training your employees as you grow every time. That keeps it consistent. When you have multiple people training multiple new employees, they can be trained differently. They can be shown different things. They can, tell one person one thing and tell another person another, and then it ultimately comes back to you as the owner, manager, and they're going to say, well, that person told me this. Well, that person told me that. I look back to poor training that I had in the restaurant where I had a sous chef who told me as a young cook, just season the top of it. That's all the chef tastes. Versus seasoning the whole ingredient with vegetables, the whole vegetable ingredient. That's a poor trainer. Have that person, your most competent person, in place to actually train your employees to prevent these lawsuits. You want to make sure, as I said, the trainer is properly educated, and you want to document the training procedures. So I say this, earlier, get it in writing. I'm going to harp on it throughout this whole time. Have everything in writing. Have everything documented. So in case you have to go to court, you have everything in front of you. You're not looking back and say, well, what date did I train this person? Who trained them? Why does this problem occur? When we have this sheet in front of us with training employees, we want to know, who was taught, what they were taught, what skills were they taught on a certain date, how did you evaluate them, how was training conducted, what dates, what training was provided, and then how do you determine the effectiveness of the training? Anybody can sit there and say, we trained this person, they're ready, but do we have a test that we actually make this employee go through to make sure that they know what they're talking about, they know what they're doing? So being able to determine how effective the training is very important. So you can say you train this person, but you could have a poor trainer in place who ultimately leads to a liability because your employee doesn't know what they're doing. Being able to resolve all these ambiguities in trainings are very, very, very important. Training also goes hand in hand with educating. And when I talk about educating our employees, I'm not just, talking about education, I'm not just talking about educating your employees, it's educating yourself. Keeping yourself up to date on the rules and regulations of your industry because they are constantly changing. Specifically allergy law, constantly changing right now, and I'm going to touch on it later on. 2 states have allergy laws. It's going to multiply. Pennsylvania is not one of them, but Pennsylvania is going to eventually be there. So we have to educate ourselves on trends. That could be just magazines, reading articles, spending that time to research your industry constantly. And by educating yourself, you're also going to educate your employees to let them know what changes are being made, what potential liabilities or hazards are out there so that they don't have problems in the future. Because if you're not training your employees properly, you're not educating them, certain liability falls on you. You could be sued for negligent hiring, for having an incompetent employee. You could be sued for negligent supervision. You can be sued for failure to properly train an employee. These are steps, little steps that we're going to take along the way in our employment law to prevent these lawsuits from occurring. How many people have been here where we had poor managers? People that we've worked for that have been incompetent, that haven't been able to motivate you. When that happens, your employee suffers, and it's a reflection of them in their business because they're not going to care. They're not going to put that time and effort. So managing our employees is crucial. So when we think about a positive manager, we want a manager who's out there to increase employee morale, keep our employees happy. And this sounds, plain and clear. And what does this have to deal with the law? Our employees are a huge liability. And when they're not in focus and not central to your business, things can happen. You could eventually be sued. So I once worked for a manager who told me, if my employees did not hate me by the end of the day, I didn't do my job. And I think that was the worst managerial advice I've ever received. I don't think it's anything that you're going to see in a handbook or any book on managerial skills. I think we have to have our employees motivated. Get them on your team. We get employees who are motivated on our team, we don't have turnover. So therefore, we're not always having to train people because that costs time and that costs money. With having a happy employee, it also enhances their service. We've all been in restaurants and in service area sectors where the person you're dealing with is just miserable. They're not happy with their job, and that reflects your atmosphere. I've gone out to restaurants where I've had servers who I can tell aren't happy, or I can see people within the kitchen who are just miserable, and I won't go back there because they're not being treated right. Somebody has to, let these management people know that with poor service leads to poor guest satisfaction, and you don't come back. But on the other side, if we treat our employees great, they're happy. They smile when they come to the table. They smile when they deal with customers. Customers are happy. They become repeat customers. You have, increased customer satisfaction. So when you have these repeat customers, we have cash flow because we're all in here to make money, and these are little steps we can do versus having a bad employee who's miserable, can neglect their job, not keep up with safety and sanitation, look the other way when food's going out. All you need is one person to get sick, one person to get injured, one lawsuit. That could be the end of your business, depending on the severity. Happy employees, less trouble. Angry employees, more trouble. Another important, as your business will grow, we'll think about, performance evaluations. So you can have an employee who's there for a year, evaluate them after 6 months. Let them know what they're doing right, what they're doing wrong, how they can improve. And that's going to be important as we touch on next with terminating employees, and that we have a record. We have a written piece of paper in front of us that we let the employee know these are the issues that we see with your employment, and they're on notice. So they can't come back to you at a later date and say, well, you never told me I didn't do this. And you're like, no, I did. Here's your evaluation. It's signed by you. You can't contend that you were never notified. Handbooks, as your companies will grow, you'll see different sizes of handbooks. I worked for Steven Starr for a little bit. The handbook was like this big. I worked for other companies where the handbook's been 2-3 pages. It's important to set aside guidelines and procedures for your handbooks to let your employees know how certain situations are going to be conducted. Handbooks can contain provisions on appearance, how you're supposed to appear at work, what your dress is. Handbooks will include what your benefits are, how to handle pay inaccuracies, your sexual harassment policy, zero tolerance. All this stuff will be within your handbook. It could be as detailed as you want it, but you need to know that you make the rules as a business owner as long as they do not violate the law. So you can make whatever rules you feel that are suited to your employment, and your employees will have to follow it. One key thing to think about with our handbooks is having an acknowledgement sheet. simple sheet at the end of the handbook that states, I read these policies and procedures and I agree to the terms. So whether your employee just signs it and hands it to you, whether your employee actually sits down and reads it, they're on notice that they are liable for the rules and procedures within this handbook. And they can no longer come back at a later date and say, nobody told me. We have our sheet. That is documented. That is signed. That is in our employee folder that we're ready to pull out versus saying, now I got to dig through papers and paperwork. I don't know where it is. It got lost. We have everything nice, organized, documented, so that when these problems arise, we are fully prepared. How do we go about terminating employees? One type thing to think about first before we terminate employees is progressive discipline. What steps do we need to take to protect ourselves? First step I recommend in clients is to go about just a verbal warning. Put somebody on notice that they're doing something wrong. It doesn't have to be documented, but when you get time that you're repeating yourself and it comes time for a second verbal warning, make sure it's documented. Put it in their employee files. These are all things that courts are going to want to see in the future with your law, with a potential lawsuit to say, here's our file, this is how I handled it. Everything is up to date, clean and clear. So after a documented verbal warning, you can have a written warning, letting the employee know that they have these issues, and have the employee sign the written warning. Another backup to let yourself know that you're fully prepared and the employee's on notice. Suspension, and then finally termination. And now this is not a guideline to handle all terminations, all disciplines, because sometimes there are very big issues and mistakes that somebody has to be terminated immediately, and you can skip these steps. But when we're talking about small infractions over a period of time, that your employee keeps on making the same mistake, they keep on doing this, these are the steps that you want to go through. Ultimately, how do we terminate? We want to conduct and document regular employee evaluations. As I mentioned, we have these files in front of us. We conduct evaluations. We let employees know, to ultimately to the point that we terminate them. They're on notice. They can't say that they were fired for no reason. We have documents. You want to develop and enforce written policies and procedures. So when we develop a handbook, let's follow the handbook. And let's follow it uniformly for all employees. We don't want to go about saying that, well, I'll let this slide on this employee I'm going to punish. If we're treating them differently, they can go back and use that against you to say that this person, say you fire an employee for habitually being late to work, but you let it slide on another person. That's what they're going to use against you. They're going to use your policy and procedure to show you that you're not following it for everybody, and I was wrongfully terminated in this respect. Prohibit on-the-spot terminations. Your employees will frustrate you. They will do things that you do not understand, and you want to fire them right away. The last thing you want to do is make a rash decision. Sleep on it. Because we don't want to get into a heated argument with an employee. We don't want to say something at the spur of the moment that we're not fully prepared that can come back to haunt us. By prohibiting on-the-spot terminations, we give our clients and as managers time to think about things. That 12 hours that you go to sleep, it may calm you down, and you may say, you know what, I'm not going to fire them. I'm going to work with them. That 12 hours, you could wake up and say, you know what, I feel the same way. I'm getting rid of them today. But you're giving yourself time to fully evaluate the situation, because we don't want to do anything rash that can come back to haunt us and eventually lead to a lawsuit. You want to review all documentation prior to firing somebody. Just make sure we have all our paperwork in place, that there's a verbal warning documented, there's a written warning, they were suspension, we have a protocol, and this person has always been on notice of what their problems are, and they haven't fully fulfilled their obligations. Lastly, when you terminate your employees, we'd want an exit interview. More than likely, you're going to terminate an employee, and they're not going to want to talk to you again. So go hand in hand. You want to keep it confidential. You don't want to tell everybody why you fired this person, because you tell one person, they tell another, who eventually tells the terminated employee, and they say, "No, whoa. I didn't get fired for that." You potentially have a defamation lawsuit because word's spreading. Keep it in-house. Keep it with those people who need to know why you fired somebody. Responsibilities to our customers. We're serving foods. We talk about a duty of care. We talk about negligence. There's 4 main factors that you need within negligence. First being a duty of care. And I'm going to make it simple for everybody here because we're all on the same page. We have a duty of care to serve food that is reasonably safe for consumption. That's our duty of care. When we fail to provide that duty of care, we fall under the guise of negligence. We can be sued for being negligent, for serving improper food, because we just need to show there's a causation between your breach of your duty, you failed to provide reasonably safe food, and the actual injury that somebody got sick. That's when we go to court for food safety. So when we talk about responding to a foodborne illness, we want to have everything documented. I've seemed to hit that spot over and over again, but we want to document everything. We want to document the items that we are serving, the parties involved, the time that this person's saying that there's actually an illness. If we have a food truck, we write down how many items and what items we sold today, so that we can do a little investigative work to see what actual item caused the illness. When was that item produced? I've worked in restaurants, and you always get foodborne illness complaints. It's the winter, people get sick, they want to blame your food, not their coworker who's been coughing all day. With the restaurant, having it detailed, we know what items that we have sold. So we can look back and say, this person ate, say, a pizza, octopus, and a pasta. I sold 70 pizzas that day. Nobody else is complaining. More than likely, it's not the pizza. I sold 35 orders of the octopus. We didn't get one other complaint. Not looking that way. We sold 4 orders of the pasta. Now we're narrowing things down. Maybe we're not turning over this product as much as possible. There's more likelihood of the item that hasn't been sold the least is going to cause the problem. Responding to accidents are very important. A simple slip and fall on your premise. We want to document it. So what do? First thing we want to do is call 911. If it's a medical issue, let trained personnel make the medical decision. If it's something as simple as putting on a Band-Aid, that's fine. If it's something that needs medical attention, get medical attention. Get somebody else there involved to fully oversee the operation, make sure this person is being safe and taken care of. You want to attend to the injured party. You want to make sure that they're safe, they're taken care of. Maybe move them out of the way of your other customers. And you want to be sensitive and sincere. You want to show that you care about them as a customer. You want to make sure that they're safe and taken care of. It's amazing how often there are going to be lawsuits, and there are lawsuits, when a customer just feels jaded. They feel that they didn't really care about me. They didn't really, give me any attention. Now I want to sue. Versus the customer that you cared for, that you were sensitive, they're going to be they're going to be less likely to sue because they feel that you've been there, taking care of them, and you're part of their team. You never want to admit your role in the accident. You never want to say, oh yeah, that's totally my fault. That can be used against you in court as an admission. It's simple as a car case. You get in a car accident, you never want to admit you're at fault. And it could be totally your fault, clear. You never want to admit it. Because once you admit it, you've signed your fate. And that's going to be used against you. Like everything else, you want to conduct a thorough investigation, and you want to document this immediately. You don't want to say, oh, I'll write the accident report tomorrow, because tomorrow you forget the exact time. You forget the parties that are involved. You didn't get this person's information. Get everybody involved immediately after the accident has been resolved and write their statements. Write what happened, when it occurred, so we have this document on file in case of a potential lawsuit. Briefly, I'm going to come back to the anatomy of a lawsuit, but I'm going to go over some simple food allergy stuff to think about, because we're dealing with a lot of food. You can skip to the next slide, please. We're going to go back to the anatomy of a lawsuit. Originally, when we talk about food and getting sued for foodborne illness, improper food, the old test used to be whether the item or the food found is natural inherent. So say we're serving chicken soup, and you find a chicken bone in it. Back in the day, the courts would say that's fine because a chicken bone is a part of chicken soup and it's fine. Nowadays, the courts are looking for reasonable expectations. With reasonable expectations, what does the consumer expect to see within their product? Do we all expect to have a chicken bone in our soup? No. We don't expect to bite into a chicken bone and crack our tooth or, scratch our throat. That is a liability. So we want to make sure that everything that we have is safe to actually serve and for customers to consume. Common food issues right now being that Massachusetts and Rhode Island are the first two and only states within the United States that has a food allergy law. Those individuals owning and operating food service establishments have to put their customer on notice of what food allergies are out there. So they have to let them know whether, Rose hinted on it earlier, milk, eggs, tree nuts, fish, shellfish, walnuts. These are all common food allergies, soy. So we have to let our customers know when these items are within our product. Simply labeling it, if our food truck, we could say we use these items. What they're looking for in restaurants, as you grow bigger, they're looking for a little menu item saying, before you place your order, please notify the customer, please notify your server what food allergies you have. People here, anybody here have food allergies? Okay. I have a shellfish allergy. I once went to a place and ate a pork belly, and you see with the Asian cuisine, they'll use shrimp throughout. And sometimes think, oh, it's only a little bit of shrimp. It doesn't matter. You can still get sick. Put our customers on notice of the products we're using. Fish sauce, Asian cuisine. I have a friend who's allergic to, bone-in fish. Now he can't eat that cuisine because you never know what's going to be there. So if we're using these products, let's notify our clientele. Gluten is another issue that's out there now, gluten-free, gluten intolerance. I worked in Italian restaurants, which are virtually impossible to be gluten-free because you have bread, you have flour, you have pasta, everything's with flour. And we have customers to come in and they say, well, could I get some gluten-free pasta? And they'll sometimes bring in their pasta with them. You have to, in this case, I would have to cook it in a separate pot. I would have to use separate utensils. But I know this because I'm educated about food allergies, food safeties. Your employees have to be educated about food allergies and food safeties. They may not understand what a gluten intolerance is. They may not understand cross-contamination. It's your job as a manager to watch over them. And when you say, touching on gluten-free, you really have to have a separate gluten-free kitchen where there's no flour, there's no cross-contamination, because flour is everywhere. When you're using it, it's in the air, it can touch and land on something and cause serious problems and reactions. So we want to make sure that our employees are there, they're properly educated, they know how to train, other employees, and they also know how to handle a food safety emergency. So when we go back to this, go up one slide to the anatomy of a lawsuit. When we deal with a lawsuit, it's going to be simple. More than likely, you're going to get a demand letter, a complaint that's going to come to your office and say, hey, I had this issue. I want my medical bills covered. I want X amount of dollars. You judge the severity of that letter. You decide whether you feel like at that point you need to contact an attorney. More than likely, having an attorney look over it will be better. It's even more important to have an attorney look over it if you're getting a letter from another lawyer. Once you're dealing with lawyers, talking to lawyers, let them deal with the business versus you trying to deal with another attorney. Things fall through, you don't negotiate a settlement, other party will file a petition saying we're suing you on these grounds, breach of contract, negligence. They'll detail the facts of the case. You answer the response saying that this is factual, this is not factual. But the most important thing to think about is discovery phase, and that this is where all our documents are in place. That's what discovery is about. The other side wants to see what was done in your case. And that's when you say, oh, you're suing me for wrongful termination. Okay, let me go get this person's file. Here you go. Here's all the steps I took. And when you present that to court, you present that to another attorney, they're going to be like, this doesn't look good for us. Why do we want to follow through and go to court? Eventually, there might be cases where you have to go to court, trial and appeal. But if we have all our information in place, we prevent this. So if you take one thing out of this whole lecture, is to document. Have proper documents in place, because these are going to be the keys to your future lawsuits.